Good morning, everyone. My name is Daniel Malloy, and I am the CEO of the Alberta Retired Teachers Association. I want to thank you for joining us today for this seminar presented by our Pension and Financial Wellness Committee. ARTA is pleased to offer a series of financial wellness seminars this month to create an opportunity for education on topics specific to retiree financial wellness. Since ARTA was formed in 1963, we have focused on supporting our members in an engaged and active lifestyle in retirement. Our holistic approach includes one of the best retiree benefits plan in the country, as well as many additional programs and services, including our discount programs, physical wellness events, social opportunities offered through our regional branches, scholarships for family members, and of course, seminars like this one. ARTA also serves as an advocate for teachers and retirees, using our collective voice to draw attention to the ATRF and teachers' pensions, the seniors' drug plan, the Choice in Education Act, and most recently, curriculum development. There are many different factors that allow ARTA to maintain such a wide reach, but in the end, it all boils down to our organization's financial wellness and sustainability. As a not-for-profit organization, we take any surpluses we generate and put them right back into the benefits plan. And because we were created by retired teachers, for retired teachers, and like-minded professionals, we remain dedicated to retirees. 2021 has been a significant year of change for ARTA as we begin to self-administer our benefits plan. While there have been hurdles to overcome in this transition, our dedicated staff have been working tirelessly to connect with each member and resolve independent, unique issues. While the initial transition is not as smooth as we had hoped, we know that the long-term benefits of self-administration will be worth these initial frustrations, one of which is increased financial sustainability and major plan improvements coming this November. We thank you for your continued loyalty and support to ARTA. With that, I'll pass things off to ARTA's Chief Financial Officer, Scott Taiwanya.
Thank you, Daniel. My name is Scott Taiwanya. I'm the CFO for ARTA. We're excited to host today our second of 3 seminars in April involving financial wellness. I'm joined today by Lito Riche, ARTA's Chair for the Pension and Financial Wellness Committee, along with Pension and Financial Wellness Committee members Blair Lowry, Sheila McKay, Ray Hoger, and ARTA's past president, Marilyn Bossert. Lisa Sissons, our Executive Administration Assistant, is also here helping us run the show. As far as some housekeeping goes, before we start the seminar, as you may have noticed, we've disabled all the attendee video and audio capability. This will help ensure a quality experience for everybody during the live web streaming. It also allows us to record this webinar for future use without breaching your privacy. With your audio muted, we encourage you to use the question and answer feature found at the bottom or the top of your screen to submit your questions. You can submit questions publicly so that all attendees can see them, or you can submit them privately so that only the ARTA staff and the presenter are able to see them. Our team or the speaker will respond to the questions throughout the webinar or at the tail end of the webinar. So for today, we have a wonderful speaker from Calgary. I'd like to welcome Matt Trotta. Matt Trotta is a tax, trust, and estates lawyer at Field Law in Calgary with a primary practice focus on creating tailored, pragmatic, and effective solutions to address the specific needs and circumstances of his clients and their families. Matt has represented clients in tax, trust, and estate matters at the Alberta Court of Queen's Bench, the Tax Court of Canada, and the Federal Court of Canada. Matt's been designated as a Trust and Estates Practitioner by the Society of Trust and Estate Planning and has completed the CPA In-Depth Tax Course. Matt's also been cited by Thomson Reuters Practitioners Income Act, the Taxation of Corporate Reorganizations, and the McCarthy Tetrault Canada Tax Service. Matt has been recognized by the Canadian Tax Foundation for his co-authored article titled Residence Post-Fundy on Residency of Trusts and Best Drafting Practices. Prior to joining Field Law, Matt practiced at a national law firm in Calgary, as well as a boutique tax and business law firm in Calgary, where he specialized in estate planning, estate administration, and solving related tax, corporate, and litigation issues. Matt also gained in-house experience at one of Canada's largest trust companies, where he was responsible for providing estate planning and estate administration guidance and solutions to estate and trust clients, advisors, and planners. Today, Matt will be sharing a presentation entitled Estate Planning Strategies and Considerations. And with that, I will turn it over to you, Matt.
Hey, thank you very much. Good morning, everybody. Thanks for joining us here. I'm more than happy to be here as well, even though this is a little bit of a different setup than we're used to. Usually these are done in person, and usually these are fairly interactive presentations, but I'll do my best to jump in on your questions as we go, but otherwise I will go over all of your questions at the end. To give a bit of an idea of what we're going to be working on today, we're going to be talking about wills and estate planning with some specific issues. Key thing with estate planning just generally is that wills are really just the beginning. You can have a really bad estate plan with a really good will, but there's a lot of considerations that go into it, and I'm going to go into the key ones. Choosing the right executor, what kind of mistakes tend to come up in wills, what happens when you have a blended or more complex family cabin and family cottage issues, general planning strategies of what I call planning for the known unknowns, and just what generally is best practices. And then from there, we're going to go into the other two primary key pieces of documentation, your enduring powers of attorney and personal directives. Then from there, I'm going to wrap it up and then take your questions as we go. So choosing the right executor is the most important thing in any sort of estate plan. It's the thing that when we're sitting down and doing a consultation, we're going to spend the most time on this. An executor or personal representative, as we're moving to more gender neutral language, is a person or persons appointed under a will to administer somebody's estate and administer any trusts that arise out of that estate. So for example, if there's any trust for minor children, disabled persons, spouses, things of that nature. Many people think that being an executor is this great gift. I like to call it the scarlet letter in many cases. You're putting yourself in the sight lines of other family members, friends, creditors, former relationships, current relationships. So it needs to be somebody who can understand those issues, and somebody who you may have had some conversations with during your life. So it's not just being tossed into the deep end. It's something more they've been prepared for over time. Doesn't matter how good we are at drafting the will, if we have an executor who doesn't know what they're doing or thinks they know better or do the best laid intentions causes a lot of issues, it can undo a really good estate plan very quickly and cause a lot of acrimony amongst the beneficiaries. So this is one of those ones we think carefully. It's not necessarily all your children. It's not necessarily your spouse in all circumstances, though in many cases on the first to pass, that makes the most sense. It's one of those things we look at carefully, and it's something that you should be able to have an open discussion with your legal counsel on, and it's something that lawyers should be looking at carefully with you and not just simply acting as a scribe and putting down everything that you tell them to put on paper. You should be asking the right questions on this, especially this. What do people do wrong when it comes to appointing executors? Well, this is not an exhaustive list, but this is kind of the big ones that we see often. Either they're too young. A lot of people want to appoint their kids. Their kids may be 18, 19, 20 years old. Generally speaking, your executor really shouldn't be younger than 25 or 30. They should have some life experience behind them, some education, some on-the-job training, because what this role is a management role. An executor is going to be working with lawyers, accountants, financial managers, pension managers, and they're essentially the quarterback of everything else. So if they don't have any experience being that quarterback, making quick, timely decisions, it's going to be difficult. On the other side of the spectrum, people tend to appoint their siblings or a friend who's the same age as them. And if they're in their 80s and their executors in their 80s, what often happens is people's health situations can change rather drastically, rather quickly, or they just may find that they're just too old for this and they don't want to do this. It may be a situation where a trust is being run for several years And while they're willing to take it on in year 1, they wouldn't be willing to take it on in year 5, 6, 7. And we'd have to swap them out at some point, and that can be difficult if we haven't thought that part through. While it's largely a management position, executors should have some knowledge and experience relative to the estate complexity and estate size. If we're looking at a situation like many of you, where you're sitting on property, maybe more than one property, investments, pensions, managed pensions and whatnot. Somebody who has some experience and understanding in that would be helpful. Somebody with a law or accounting experience intuitively makes a lot of sense, but not every type of law and accounting is the same. Is a personal injury lawyer going to be as good as an accountant in managing an estate? Absolutely not. Actually, I shouldn't say that. Maybe they'll be okay. But that's something that is a case-by-case issue and something to think about carefully. How far somebody lives away from you shouldn't be a big deal, but it is. Under Alberta law, if you are a quote-unquote foreign personal representative, which is anybody outside of the borders of the province of Alberta, they may have to put up an insurance bond or surety on the estate unless it's waived by the beneficiaries and accepted by the court. If a beneficiary wants to start problems, this is where they start, and they'll prevent a foreign personal representative from acting without an insurance bond. And these things are several $1,000s. One of the recurring themes that's going to come up during this presentation is whether or not an executor is in a conflict of interest with one or more beneficiaries. And it's not always the way you think. But often in blended families, that's a big one because spouse may not be mom or dad to the kids. You may be passing on something to one kid over than another. May have been some loans or gifts during life that your children may want to look the other way on to benefit themselves or try to make another sibling pay back because, as many people do in families, they don't paper things super well. So that's something we want to watch for. Too many co-executors is a big one. There's, one of those things where there's no safety in numbers and this sort of thing. It's, having multiple executors means there's multiple decision makers and multiple opinions and multiple feelings and multiple, so-and-so has a friend who's a lawyer that says X, and that sometimes can cause a lot of problems. So it's one of those things to kind of, weigh carefully. Some estates do justify having a couple executors, but most don't. But with that, if you have lots of options, maybe you should be appointing multiple alternates in case situations happen. So this is a good way to adjust for if executor appointees are too old or too young. And the big one as well is, do you have to consult prior to appointing? No, but you should. I've had lots of situations, including at the trust company, where people weren't consulted ahead of time and they realized they can't do this. So I had a question just pop up while I was talking here about whether or not all adult children should be included in as a will as a beneficiary. To that, I would say no, unless they are family members under the Wills and Succession Act. And what that is essentially an adult child who's dependent on you by means of disability or by means of being in post-secondary education and unable to leave your home. Otherwise, it's minor children that you'd have to deal with. Its situation will vary on whether or not you should include all of your children. One of those things, and I'll kind of go over this a bit more later in the presentation, is that equal isn't always fair and fair isn't always equal. Another question about what about appointing a bank representative as an executor? I'm not sure if you mean like a trust company. Trust companies are great options in certain situations. They're not exactly the cheapest option, but as a colleague of mine says, it's a good way to guarantee 97% of your estate ends up with your executors. Sometimes they're good options, and it's one of those situations will vary, but if you have a complex estate or you have a complex family situation, trust companies can be a really good option. So what do I see in wills that make my skin crawl and make my blood run cold? The assumption that the will is the end of the story is a big one. A lot of times where people have pension designations, and that's not going to be a problem here because they're managed, but when you have situations where people obtained policies, insurance policies, or bank, TFSAs, RSPs, RIFs, and they're not properly managed and the designations aren't up to date, those can create a really big problem. Best example, a couple times I had to deal with CRA was the RSP went outside of the estate, but the tax bill goes to your estate. And that was the biggest asset. So we created an insolvent estate and spent 2 years going back and forth with CRA, chasing money, and eventually getting it paid off. And nobody was happy at the end of the day. The next big mistake is incompetent and inexperienced executors. I'm going to be beating that horse all presentation long, but that's something that can cause a lot of problems. My favorite is when people tell me that their family is going to get along and sort things out. Sometimes my how I come across in meetings as being a storm cloud on an otherwise sunny day, but nothing is more emotionally charged in a lot of people's lives than the loss of a loved one. And so a well-crafted estate plan, a well-crafted will is going to contemplate some of these issues. Just using that question from earlier, if we wanted to disinherit certain adult children who don't have a legal right to any part of the estate, we might do a statutory declaration as well, laying out the reasons why this person is being cut out of the will. We may not want to put it in the will itself, but we want it there in case they challenge. Then it's another voice from the testator saying, here's why I did what I did. And importantly, the challenge wouldn't be that they have a right to something. The challenge would be you were incapable or somebody else was making you draft the will this way. And having the supporting documentation helps protect your interests on that sort of thing. So, the will is not the end of the story when it comes to that kind of estate planning. One of my favorite is confusing asset ownership. Sometimes people don't realize that their will doesn't get to will out jointly held property unless they're the last to pass. Jointly held property typically goes to the surviving joint tenant or joint owner, and they retain the right on survivorship. So there's often cases that I've seen where somebody tries to set up a trust for their spouse with jointly held property. So that's always interesting. Business assets, same thing. They think that if it's in their corporation, it belongs to them, but they only can will the shares. Not contemplating debts, taxes, and creditors is a big one. Typically, any well-drafted will, or even not so well-drafted will have some language on debts and taxes, but where we can run into problems is where people come with really good spreadsheets and say, this is what my estate is worth today. And as we saw from the budget yesterday, things can change rather drastically. And that was actually a pretty minor budget from an Income Tax Act point of view relative to some of the seismic shifts that we've seen over the past 5 years. So what contemplates debts and taxes today may not contemplate debts and taxes tomorrow. Assets outside of the jurisdiction are an important thing to bear in mind. While an Alberta probated estate would only contemplate Alberta property, that will can go to other jurisdictions. And we'll want to make sure that we've thought about, can we administer in that jurisdiction? And do we want to? One of the things with a lot of other provinces is that they have probate taxes. They'll call them fees, but it's really a tax on a percentage of the estate. And we may want to think about other strategies to make sure you're not handed a bill on that. Again, overstated and understated that spreadsheet mentality where my estate's worth $1 million and I'm going to gift like it's worth $1 million. Bad idea almost all the time. Contradictory or unnecessarily complex language is a fun one. I see this a lot in homemade handwritten wills where somebody tries to create a trust, and you probably see this as teachers where students try to get as articulate as possible because they think that they're going to get graded higher on diction even though the actual wording makes no sense. And that's exactly what happens in wills, is people use ye old language that we don't even use anymore, and it creates a lot of contradictions. Ruling from beyond the grave is a really fun one that we see, where somebody will set up a trust for their 50-year-old son or daughter who is an executive, and then we have to break the trust up to try to resolve issues that will arise from it. Gift over provisions are something in a will that are very important. You know, we like to contemplate that everybody we want to benefit is going to be around when we pass away, but that's not always the case. And then, so what happens if a gift fails? If the will doesn't contemplate that, we go to the statute, and that may create some situations that we don't want. So for example, we may really, really despise a certain uncle or nephew or niece. And if it goes into intestate succession, everybody within that class gets an equal share. So that uncle may get the benefit at the end of the day if we're not careful. That's, again, same thing with residue not being fully contemplated. If we don't have language in the will that lets us figure out what we do with every last penny, we're going to have problems. Testamentary trusts are a big issue. Same reason people draft them overly complex, or they don't think them through and don't think about taxes on an annual basis, administration costs on an annual basis. And my favorite is the assumption of a simple estate. You know, as a tax specialist, I hear it a lot, even though people coming to me are usually not coming to me with a very small estate. Usually, at very least, there's a $500,000 property, some bank accounts, some investments, and enough that there's really some considerations. But simple goes beyond just assets. The question that came up is what I mean about creating a trust. So a trust, a will itself is a trust that arises on death. And essentially what that means is we're giving a gift to somebody to be held upon terms and administered by a third party, a trustee. So a testamentary trust is essentially saying, in my will, I'm going to set aside some money, and that's going to go to this person under these terms until they hit a certain age, until they complete a certain task, and then if they don't, it goes a certain way, and if they die before this happens, it goes here. And that's kind of what we mean by that. So when we talk about what's not a simple estate, this is usually what I'm talking about. Everybody knows if they've got $100 million of assets, they're a complex estate, but people don't realize so much, even with families, that they're a complex estate. And so what does that mean? I've got a few examples up there, but generally speaking, it's, you know, not your quote unquote nuclear family, which is not as common as people think. Spouses from other relationships, or with children from other relationships. Your children may have this sort of situation. Or some of the more common ones that I see are significant age gaps between spouses. So for example, if you're over the age of 65, we can engage in some different kind of tax planning for persons over the age of 65. But if their spouse isn't, then we can't use jointly held property. So there's little things that we need to consider, or to consider that if there's an age gap, one of the spouses may live longer than the other spouse, and plan for that. Citizenship is a big one. Every major firm in town will have a page in their questionnaire about whether or not you're a US citizen, because the United States instantly makes things complicated. They are one of the only countries on earth, I think the only first world country, that taxes on the basis of citizenship versus residency. So even if you're resident in Canada and you're earning your income in Canada, you still may have US filing obligations on an annual basis, and by extension, so may your estate. Family members in multiple jurisdictions is a big one that we come up with a lot. You may have family in BC, family in Ontario, family in Europe or Asia, and this has a lot of planning ramifications, because some jurisdictions have inheritance tax. In Canada, we don't, at least not yet. But you may have that issue to think about, and whether or not the will has the right language for that. Residency of the trust and the estate for tax purposes can really be frustrated by having people in multiple jurisdictions. If you live in Alberta, you die in Alberta, you settle a trust in your will for somebody and they live in Ontario, guess what? We may be paying Ontario tax rates for everything. So we have to be really careful with that. We've got a question here about considering gifting seasonal property to your son who's married. So this is a very complicated question here, but to give you a kind of a high level answer, depending on where your son lives, there may be some matrimonial property issues, but generally speaking, inheritance in Alberta is exempt until they commingle it. And the growth on it may also become subject to a matrimonial or family property law claim upon marriage. I would always recommend always transferring it between family members. And if they want to further add their spouse or they want to do something like that, then they can go ahead and do that. But from an estate administration point of view, I would say keep it within the family, and depending on the size of the property and how it's used, we may want to consider a trust within a will. So I've got another question on that sort of thing. I might keep some of these questions towards the end, actually, just because they're fairly complicated questions. So I think what I'm going to do is I'm going to hold this next question for a little later in the presentation, just to kind of keep things going. But they're very good questions. So what do we see with these complex family situations? What causes problems? Failure to communicate is a big one. More and more families are doing family meetings. And it doesn't necessarily have to be the Shaw family or the Mannix family. It can be families with net worths under $1 million that do this, because they'll fight just the same way. And just for everybody to be open and honest. One of the things that, really doesn't shock me anymore, but it used to when I was a younger practitioner, was when clients wouldn't tell me the truth. If I don't know what the family situation is, I can't plan around it. And if I can't plan around it, then we're kind of playing with fire and hoping things work out, which is not what you hire a lawyer to do. Lack of tax planning, lack of family planning, that's a really big one, because I get a lot of questions about whether or not we can keep, actually a lot like these questions that we're getting here about what do we do on spouses. And a lot of times the solution is your spouses need, or your kids need to have prenups and cohabs, and there's only so much defense an estate plan can play or a trust can play. But there isn't an understanding between the spouses, things can be vulnerable. And that's why we get into the family planning as an important aspect. Tax and trust residency, as I mentioned before, is a big one, and one we need to watch carefully whenever there's people in multiple jurisdictions, and it's one that's often missed by lawyers and accountants who aren't attuned to these issues. Naming family members, and again, we have the situation where you have a spouse from a prior marriage and kids from a prior marriage, and are they going to get along? Tough to say. A lot of clients like using, or think they like the idea of a mutual will, which is essentially husband and wife have the same will, and in the death of one, it works afterwards. It's a concept that doesn't really work so well in Alberta, and arguably not even recognized anymore with the new legislation. But the problem that comes up with that is people get remarried, people get new relationships, people have new legal obligations, maybe an adult child becomes disabled and moves in with them. These mutual wills and testamentary contracts that try to say you can only do things a certain way, they get locked in, and then you're dealing with a conflict of laws. Direct distribution of estate rather than use of trust is one that comes up a lot, where if we gift everything to the surviving spouse and it's not jointly held, we don't have control about whether or not part of it goes to their spouse's family, if it goes to other relatives. where it may not go the way you want it to go. From there, failure to consider burial and funeral arrangements is one that you wouldn't think would come up a lot, but I've had a few situations where clients had a certain religious background and the family wanted to do something a different way. And it created a fight between the family and the friends and the spouse, who all saw things a different way, but of course the will was silent. Poorly conceived testamentary trust we've talked about quite a bit, and one of my favorites is, and it's kind of come up already in this presentation, is transferring assets into joint ownership without proper legal advice. So moving things into joint ownership with somebody else can be very problematic if we're not careful. It can create family law issues, as I've alluded to before. It can also create tax issues because technically it's a disposition. If you're adding somebody as an owner, they're getting some sort of beneficial right. So we want to be careful on that. And we want to kind of look at that carefully. We're also attracting your property to that person's creditors potentially, and they'll have to prove that they're either holding it as a trustee, but again, we need the right paperwork and we have to make sure we have it planned out properly. So one of the things, before I jump into family cabin, there's a really good question here about the legality of handwritten wills. So in Alberta, we're one of the few provinces where we still have this. A lot of jurisdictions have done away with these. They're referred to as holograph wills. And what a holograph will, all it needs to do is to be all in your handwriting, not witnessed. And that's essentially the test for a holograph will. Holograph wills are also one of the biggest sources of expensive estate administration because they are almost always missing something big. A lot of times they'll name an executor, great. They'll say we want property to go to somebody, which is also good, but they don't necessarily say what will happen if somebody passes away. They won't say how we pay debts and taxes. They won't say how we deal with real estate. Can we get lending? Can we gift assets in kind? And these are all things that, while there's general authority under the Estates Administration Act, without specific authority, it can come into some problems on that. But the essential pieces are to name your executor and name how you want the property to go. But bear in mind, holograph wills tend to be false economies. I've just recently worked on a file where somebody did a holograph will to save money on a lawyer, and we're already up to $20,000 in legal fees because they had a family business. So one of my pet peeves is the idea of the family cabin being this gift to the kids, and it's almost never a gift. It's almost always a curse. There's some families it works out well for, but a lot of people see their vacation property as something to keep in the family, and it is a noble intention. A lot of estate administration issues arise from what we do with this family cabin or cottage. And I just want to stress that this is not an exhaustive list of considerations of when there's a family cabin or cottage, but these are the big ones. And it's important to note that these things are often not well shared between siblings. Everybody wants the quote unquote good long weekends. Nobody wants to pay the capital expenses, especially if there's a situation where there's multiple children and there's a disparity on income. That often creates a problem because, well, why should I pay it? You have more money than me. Mom wanted us to share it. Well, what does sharing mean? And so we always want to think about this very carefully. And it's very situation specific. And ironically, a lot of times the best thing to do is just to get rid of the property during your life. Enjoy it while you have it. One thing to bear in mind is a lot of people, especially in Alberta, their family property is in BC, or it's in, shockingly, more often than not, northern Saskatchewan, or it's in Washington, Idaho, Montana. It's not necessarily in Alberta. That means additional state administration in many cases. It means, especially in BC, a lot more tax. And it can create some complexity where at the end of the day, it may not justify the cost for that complexity. And it may be something that your kids ultimately don't want. So I think in many cases, what's worked well is to have that conversation with the family early on what they want to do, but be prepared to sell the property. If it's during your life when you're ready to move on and when you don't want to use it anymore, that often is the way to go. But we can also set up pretty complicated or pretty simple but thorough structures on ownership. We can have it put into a trust when you pass away that has some money, and when the money's gone, so is the cabin. There's lots of different things. The key takeaway is that it's your property and it's your gift, and you make the rules on it. And just simply handing it off to the kids may not be the best solution, though. Generally, wills, the big difference between a lawyer who drafts wills and a true estate planner is the level of complexity into these known unknowns that they'll go into. When I sit down with a client, I usually will tell them that a good plan will be planning for 3 contingencies. Those contingencies are that you pass away within 5 years, you become incapacitated within 5 years and are unable to amend your plan ever again, and you may live for another 20, 30 years. Or we're back in 5 years, everybody's doing great, we're making little changes to an existing estate plan to adapt to changes in income, changes to lifestyle, changes in family, preferably, additions rather than subtractions, but that's typically what we're planning for. We want these things to be able to stand up as is to the best extent possible. What I'll sometimes do when I'm looking at somebody's plan is cross out half the beneficiaries and say, does this still work? Is this still what you want? And if the answer is yes, then we've got a good plan. If the answer is no, then we may want to think about how we're allocating percentages and whatnot. We need to, a lot of times I'll see where people aren't thinking about future children or grandchildren, even when their kids are relatively young. There's a term in trusts called the precocious toddler and the fertile octogenarian, which essentially means you're never too old or too young to have children because hypothetically things can happen. And so we should be planning for that. Estate value swings is something that isn't planned often enough. One of the first estate litigations I worked on, we thought the estate was worth 25 million. It was right around where oil and gas went down into the tank for the first time, and it was worth less than half of that. And the problem was the family members were all getting a percentage of what was left after a bunch of specific gifts. And because the value dropped so much, family friends ended up getting a bigger share than the actual family. So that created a big problem. Thinking about the future marriage or divorce of beneficiaries is important, as evidenced by some of the questions that we've had so far. And it's something we need to be thinking about carefully. Conflicts and litigation happen even in a peaceful family. And so we want to think about that as much as possible. One of my favorites is problematic or aggressive tax planning and compliance. Even when people think they aren't getting into anything crazy with tax planning, we also have a lot of situations where people will do it themselves on their tax returns and make a lot of little mistakes, especially if they're doing a little side business at home and not claiming their expenses properly. And this can be a real problem for an executor because they become legally obligated to the extent of whatever they distribute from the estate. So that's something that we need to have good language in to allow us to do tax repair, tax planning, tax compliance, and to be able to adapt to changes in legislation. If we were doing planning 10 years ago, what was in vogue were these long-term testamentary trusts where you would hold property for kids and grandkids for 50 years because it was income splitting. It was taxed at the same rate as an individual with the same graduated rates. In 2016, that changed. And all of a sudden, those trusts that were created under wills were taxed at the highest rate. So all of a sudden, it wasn't such a good idea to do that anymore. And some of these trusts still haunt us. because they don't have an easy way for us to wind them up early, and we are dealing with having to pay high tax or having to expense out the trust. So what's the best practices after all the negatives? Using an experienced estates lawyer. Bonus if they're a tax lawyer as well, because, or if they're a family lawyer as well, because depending on your family, the big issues are going to be related to family law and or tax law in an estates context. But either way, somebody who practices in 8 different areas of law is probably not an expert in it and probably doesn't know what they don't know, which is a problem. Consider your appointees very carefully and be willing to ask tough questions in advance. Tough questions to your lawyer, tough questions to your appointees. One thing that often gets overlooked is gifting specific items. And people will think, okay, well, I'll give away my car or I'll give away my Rolex, but they don't think about family photos or maybe war medals that they inherited from great grandpa. And those things can really cause issues in an estate. And so best practice is to consider, is there something that might have a high sentimental value as well as financial? And from there, consider your goals and objectives carefully and be honest and introspective. Are your kids good with money? Are they really bad with money? Do they need to be in a trust for 15 years where we're filing tax returns for 15 years? Are they good executors? Do you appoint all of your children or just one of them? Or do you appoint none of them? And be willing to ask those questions to yourselves, and then be willing to have those questions with your professionals. One of the things I've talked about throughout the presentation is estate by percentage versus specific dollar amounts, because those change a lot. And so goodwill will typically have most of the estate distributed by a percentage or number of equal shares that changes depending upon who's alive at the time. Charitable donations and gifts of friends are always an option. Your beneficiaries don't have to be family, and that's really important. With charities in particular, there can be some really nice, cheap and easy tax planning. If you gift publicly traded securities, they go at their fair market value, but you don't realize a gain on them if you donate them to charity. So that can be a nice way of saving tax 2 ways and helping out a cause that you believe in. So that's something, little things that we can do that don't cost a lot of money in setup, but that can save a lot of money in the long run. One of the things that's really important is my job is often to be the storm cloud in an otherwise sunny day. And that's really the same attitude you should have when you look into your estate planning. Hope for the best, plan for the worst. What happens if everybody in your immediate family passes away? Hasn't happened yet in any file I've worked on, but it's come quite close. What happens if there's a lot of medical expenses that are needed in the last couple of years that aren't covered? And plan for that. And the open dialogue really helps with that, because a lot of people will cause issues in an estate administration because they're caught off guard. The last thing they see from mom or dad is, I didn't think you were very good with money, so you get your stuff in a trust that's administered by your older sister. Not a great way to do things, and it can cause a lot of problems and put a lot of pressure on that other sibling. Keeping organized is huge. You know, the lawyers, we will keep track of certain things. We'll aggregate as much information, as much of a snapshot as we can, keep some key contacts and phone numbers, but we're not actively maintaining your designations on your insurance policies or pensions or TFSAs or RSPs. We're not holding your passwords. You definitely don't want us doing that. But those are things that should be available to an executor to be able to act relatively quickly. And so having that stuff in place, having those conversations in place will help reduce stress at that key time. And most of you at it yourself, maybe pour a tall glass of wine and look at it carefully, and go from there. And then every 3 to 7 years, then come in and talk to a lawyer and make changes, because good chance, even if your life hasn't changed substantially, your the legislation around you has. So a question that came up is, having an executor who lives in BC, is that going to cause that executor a lot of complex issues? It really depends. Typically, not really, except for the fact that they're a foreign personal representative. If we are setting up trusts, we'll want to watch if that person is a trustee, because for tax purposes, the tax residency of the trust is where the central mind and management is. So if it's in BC, then we may be taxed in BC. And right now, it's slightly higher, but historically, it's been a lot higher. So we'd want to watch that carefully. If it's a situation where we're distributing everything out, there's no trusts, we administer in Alberta, it may not be a big problem. And if that's the best person, we adapt to the situation. I've administered estates where the executor was in Europe, and they were the best person for the job, and we just rolled with the punches. So from wills, we go into the other two key parts of an estate, which is the enduring power of attorney and personal directive. I get some flack from some of my colleagues, but I consider these to be even more important than a will, because if in a will, you're gone, your problems are over, it's somebody else's problem, as cynical as that sounds, and there is a statutory framework to administer your estate. It may not be exactly how you want it, but your family can get from A to B. Enduring powers of attorney and personal directives, you're very much alive. You may be incapacitated permanently or indefinitely, and we need to make it very clear who cares for you, who cares for your personal affairs and your financial affairs. And there is no statutory framework for this. You have to go and get a court order for trusteeship and guardianship if these are not in place. And that is first person gets to decide. And it's a costly and adversarial process in many cases. So what is an enduring power of attorney? It's a document that authorizes a person to act on your behalf on your estate, your property and financial affairs. Typically, there's two types. One that's immediate, that as soon as you sign it, it's in effect, and you can revoke it at any time that you have capacity. What makes it enduring versus just a power of attorney is that it will continue notwithstanding your incapacity, and notwithstanding that you can no longer revoke it. The other and more common one is springing. And this is what most people need, where it comes into effect on a specified event. And usually that's incapacity is determined by two medical practitioners. And usually I like to say it should be a doctor you know and a doctor you don't know. If they both come to the same conclusion, you're probably incapacitated. What should a good power of attorney have? It should have flexibility and powers to allow them to deal with your business, with your personal, and to engage in tax planning. Tax planning is not necessarily a massive series of transactions or something like that. It may be something as simple as being able to designate principal residence and things like that. One of the tests that I typically have to see if somebody is an ideal candidate to be an attorney is how many restrictions are you putting on them. The more restrictions that you want to put on an attorney, the higher the chance they're not a good candidate. But what this ideal attorney should be is somebody who you trust and has similar values. This is also a place where a trust company may make sense in certain circumstances, because they're able to manage the finances and take a lot of the emotion out of it. This is also where location is important, but not fatal. So if you had, for example, somebody in BC, that's fine. Where we want to watch is if they're US residents, because a lot of investment advisors can't take trading instructions from a US resident. So it's something to kind of be very careful with who we're appointing. And again, spouse often makes the most sense on the first of you to become incapacitated, but not always. If you have a situation where mom does all the finances, all the bookkeeping, all of that sort of thing, and dad doesn't. Dad may not be the best choice to be the attorney if mom becomes incapacitated. It's one of those things where there is no right answer, but there's a lot of wrong answers. And it's going to be very situation dependent. The other side of the coin is the personal directive. And it goes by a lot of different names in a lot of different jurisdictions in Canada, let alone the United States. But essentially, this document allows somebody to make personal decisions on your behalf if you're incapacitated. Unlike a power of attorney, personal directives can only come into effect if you're incapacitated. You can't designate somebody to make social decisions if you have capacity in a document like this. There are co-decision-making orders through the court system, but this is intended to fill in for you if you are unable to act. This cannot be a trust company. They will not accept these appointments. The idea of whether or not they pull the plug is terrifying to a bank, and rightfully so. But this is something where, again, family members or friends are the best choices, but not necessarily the family members you might think. Spouses make the most sense in the first instance, but again, there may be situations where a family friend or one of your children makes sense. There is a lot of overlap between a personal directive and an enduring power of attorney. And that's one of the common issues, is that we don't have an understanding of where they overlap. Best example of where they overlap is working, maybe moving into a nursing home, because that will affect the property, that will affect monthly expenses. So that's the attorney, but that affects where you live, who you associate with, medical decisions, and social decisions. So that's also your agent under your personal directive. So if they don't agree, who gets to decide? And a well-drafted document will have a tiebreaker provision. It may have reporting provisions to say, you have to talk to family members, even though that's not binding. It helps you make an informed decision. And so that's one of the big problems with these documents, is that a lot of them don't speak well together. And then from there, it's the usual suspects. Bad appointee, not getting along with family. One that comes up a lot is failure to keep records. What a lot of attorneys don't realize is that the executor of your estate can compel them to provide an accounting of everything that they've done so that they know what they're starting from. So best practices for an attorney and an agent to keep records. Same with an agent. It's important for them to keep records of the decisions they've made so that if anybody challenges them or has questions, they have proof of what they've done. Moving assets into joint ownership is one that comes up a lot, and it's rather problematic. An attorney does not need to hold property jointly with the donor. It creates a lot of issues. The attorney is the donor, is you for those purposes, so they don't need to have it in joint ownership. But what that can do is the same thing about moving assets into joint ownership as part of estate planning, is it can attract creditors, it can create a disposition, it can cause some problems. It also assumes that the beneficiary is going to survive you, which can be a bit of a problem. And I've had a file where that actually happened, where somebody moved assets into joint ownership as an attorney, thinking that the person they were moving into joint ownership was going to survive mom, and they didn't. And so not only were there tax issues, there were estate issues, because it was a different beneficiary if that person predeceased than would have been on their side. Causes problems. Then from there, tax filings, big problem. Those issues can linger with an estate even if you don't know it. They don't budget for short-term and long-term care well. And too many appointees is another one I want to talk about in a bit of detail. There is such a thing as a joint and several appointment, where you can say, I appoint my 3 kids and any one or any 2 of them can make decisions. Suffice to say, that can be a recipe for disaster in a lot of cases. You can have two ganging up against one. You can have people making contradictory decisions. And I know, talking to a lot of doctors, nothing frustrates them more than that when they're in a high pressure situation. So we want to think about that carefully. People who don't fully comprehend the issues can cause a lot of damage without being intentional in it. And so that's something we want to be very mindful of when we have appointees. Question here. Is it a good practice to have the same person as your agent and attorney? It can be, absolutely. The nice thing about that is that they control both, and that can be very helpful. Sometimes people prefer to have different attorney and agents so that there's a little bit of oversight on those decisions that overlap. Or in the cases where an attorney is a trust company, there's a little bit of professional support. And sometimes people will want that. Another question here, really good question, is can I have joint executors, one in Alberta and one in another province? Absolutely. And that's one of the ways that we will bypass the need for a bond requirement. So if there's one person in Alberta, then the bond requirement doesn't apply, because the whole idea behind it is that there's recourse against the executor in the jurisdiction. So there is a executor who's the lightning rod there then. So that often will work quite well. The only thing you want to be mindful of is that that co-executor will have to be in town to deal with certain things. One of the few positives of the pandemic is that a lot of things have become more electronic, so that becomes less of an issue than it used to be, but it's still helpful. So now I'm going to try to tackle this earlier question here, because I think it's an important question to talk about now that I've sort of covered all the bases. What are the consequences of gifting seasonal property to your son that's married? Again, that's tax problems potentially. There's marital problems potentially. I recommend it being transferred, if you're going to do it, to your son, but consider whether or not it should be a fair market value transaction, or consider whether or not it should happen after you pass away. Depending on the property, and depending on whether or not we're dealing with arm's length parties, it could matter whether or not you send it to your spouse or his spouse as well. But if you gift it to your son and his spouse, you half that property will go to her for sure. And she may potentially, depending on how their asset values are in the event of divorce, it could be slanted in her favor, because it would be inheritance, but it would also be a gift to both. So it becomes murky. So you'll want to be careful about how you do that. And so hopefully that answered your question a bit better. So to conclude, I really want to emphasize the fact that there is no one size fits all in a lot of estate planning. That $75 will kit at Staples is exactly that. It's a kit, but without the thought that goes into it. I have never drafted a will that was more expensive than $6,000, and that was a 8-digit estate with multiple trusts in the will. The will looked like a small novel, but I've never done a court application for less than 8. And it's these wills that, it's not even that big of an estate, but they have these issues because somebody went to a cheap lawyer or they tried to do it themselves, and then they created ambiguity. And it's not to say that never happens, but you're rolling the dice. And so it really depends on personal circumstances and financial assets, and a lot of introspective thought. And when you create a plan that works and it's effective, it creates a lot of peace of mind, because a lot of people don't like the idea of thinking about estate planning. They'd rather think about anything else in the world, but it's like insurance for your house. You don't want your house to burn down, but if it does, you're very happy you had that insurance. And when it's done right, the result tends to be a greater flow to the next generation without issues during a time when emotions will be running high. And so I see there's a couple more questions here. So I'll jump on those right now. How do you gift a car or a house? Good question. How do you want to? There's a couple different ways we can do it. We can specifically say, if at my death I own this vehicle, then it goes to this person if they're alive, and if not, otherwise. I will often do what I call an omnibus domestic articles clause that says anything that wasn't specifically gifted, vehicles, artwork, loyalty points that we're allowed to transfer, because I know some have different rules, but anything of that nature will go to a set class of people or one person, and then they can do with it as they feel. Or in the absence of that type of clause, it would just form part of residue, and it can either be sold or it can be given as part of a share. Next question. Any advice for a dual citizen planning to retire in the States? A lot of advice. My first thought would be, you'll want to figure out how things are going to be held. You'll want to think about departure tax. You'll want to think about U.S. estate tax. You'll want to think about U.S. gift tax. And U.S. gift tax is especially tricky because for estate tax, there is a treaty carve out for Canadians so that we get very similar treatment, but there isn't that for gift tax. So if you move to the States and gift something to gift property to a Canadian resident, if it's American property, that could be a highly taxable transaction. So we'll want to think about that carefully. You'll have increased tax compliance, so you'll want to have a good accountant. You may want to have an enduring power of attorney and living will in that jurisdiction as well as Alberta if you're going back and forth. And so the key takeaway is you'll want to sit down and do some planning. Good question, very good question. Next question, how much money should be offered to a friend or family member who have taken on the role of executor? This is another really good question. And of course, the statutes don't really give a lot of support to that. There's been a bunch of case law where the courts have held what's considered reasonable compensation for an executor, and that's between 1% and 5% of the value of the estate. 5% tends to be trust companies, professionals on highly, highly complicated estates. A non-professional tends to be around 3.5. That's what they're entitled to. But realistically, what I advise executors to do, because they have to get this past beneficiaries, unless they want to pass an accounting through court, is keep a logbook and charge a reasonable hourly rate. The one thing I do recommend, though, is if you're otherwise a beneficiary of the estate, bear in mind that your fees for being an executor are taxable income, but your inheritance wouldn't be. So sometimes what we do is we'll sneak in a gift to the person who may be acting as an executor. Wink, wink, nudge, nudge. This is an executor compensation, but it really is. At least that way it's a gift. And they can still be reimbursed for their expenses. It's not taxable income. But a lot of times we need to be reasonable about that because it has to be a gift. And if they choose to take anything above that, then it is taxable income. So hopefully that answered your question. It's a fairly nebulous, individually specific thing, but that's usually how we do it for executors. Trust companies will have a fee agreement that will go by a set percentage based on the value of the estate, and that typically will land in somewhere between 1% and 4%. Next question, if you and your spouse own a plot of land together and one person passes away, what are the tax implications, and is there a way to prepare for them better? Good question. If it is jointly held, or if it will, quote unquote, vest indefeasibly in the surviving spouse, either directly or through a qualified spousal trust within 36 months, qualifies for a rollover. Otherwise, it would be taxable on death. And sometimes it may make sense for that to be taxed on death, depending on why. And there's the ability for your accountant to file an election for part of that. So it's pretty straightforward on spousal rollovers in most cases, but we'll want to watch an estate plan to make sure that we're not doing something that inadvertently causes it not to vest in the spouse, and in which case the taxes would apply. Next question. What are some considerations a single person with no dependents really need to consider? This is a really good question. It doesn't get asked often enough. You don't have the burden of obligations to anybody. So that means you have a lot more leeway in how you want to plan. But your big considerations are going to be, who would you like to see benefited? So do you want to gift to friends, to other family members, to charities? And who do you think would act best as your executor, agent, and attorney? Those are your big considerations. And I'll also just add that you also wouldn't have the same sort of tax benefits on passing that somebody with a spouse would have. And in very limited circumstances, a disabled beneficiary, there's some options there as well. But so there'd be a bit less on the tax side of easy solutions, but does not necessarily say that there would be no solutions as well. So perfect. That seems to be all the questions right now. So thank you for that, and thank you for having me.
Awesome. Well, thank you very much, Matt. We appreciate you giving us such a well-planned and well-laid-out presentation. I'd like to thank all attendees for joining us, and this now concludes our webinar. Have a great day.